Welcome to Channel 17, the Town of Colonie Government Channel.
Hello, I'm Colonie Town Judge Peter Crummey, and welcome to Benchmark. We'll explore a variety of issues involving our justice system, our legal system, and how they intersect with the citizens of the town of Colonie. Today, we are truly fortunate to have Albany County Family Court Judge Gerard Maney with us. Judge Maney, as many of you know, has been serving as our Albany County Family Court Judge since 1991. Judge Maney was recently re-elected last fall to his third 10-year term as our Albany County Family Court Judge. Judge, thank you very much for joining us today.
Thank you, Peter. It's a pleasure to be here.
Well, I can tell you, Judge, that you and I have a lot in common as to what our courtrooms are like, and both very busy places. Both sometimes covering similar issues and sometimes not, sometimes covering similar parties as we move forward in the court system. Many times there will be people who have cases pending in front of the Colonie Court and also simultaneously the Albany County Family Court. And you and I have spoken about the case volume that you have seen increase in your own courthouse since you became an Albany County Family Court Judge in 1991. Judge, what was the volume in 91 and what is it now?
Well, Peter, obviously society has changed quite a bit in the last 20 years. We've gone from filings of 8,000 now to 18,000. So it's a very busy place.
Well, you're not kidding, Judge. And how do you find, what are the typical cases that a family court judge would preside over? Are there certain ones that seem to be more often than others, or how does it break out, Judge?
When the legislature created the family court in 1962, they carved out from Supreme Court everything except divorces. So divorces go to, matrimonials go to Supreme Court, and we have everything else. So we have custody, visitation, neglect and abuse of children, JDs, PINs, support, adoptions. But the average case would be a mother and father who have a problem in their family, whether they're together being married, or whether they live together, or whether they live separate and apart. There's some relationship problem or some problem with their child or children. And the normal petition would be, because there's a relationship problem, would be a family offense petition. There would be a custody petition, and more than likely there would be a support petition. And if paternity's never been established, it would be a paternity petition.
Judge, do you find that almost nearly half of your caseload involves cases just like that?
Yes, that's primarily people who have children together, whether they live together or not, do have common problems during the course of the lives of the children, and sometimes they need to come to family court to do that. But I would tell you, Peter, we utilize the services of a mediation agency, which allows us to direct people to go to mediation where they can work on these problems rather than inside a contentious courtroom. And we've been very successful with that. It's about a 90% success rate when mothers and fathers are willing to go to mediation to sit down and mediate their differences.
Judge, I know, and I've heard from a variety of attorneys and litigants as well, that when in your courtroom, when in their first appearance before you in a custody matter just like this, you take the time to discuss a variety of global issues, that encouraging both parties to consider a variety of things that should be paramount in their concern for their children, and describing situations which puts them all at ease, but also lets them know that you have a focus and they need to be focused on what's important. And that's been well received in your courtroom as well.
Well, during the last 20 years, Peter, I found that we can litigate almost anything because the litigation model is what we know in New York State. You know, hire attorneys, go to court, you know, settle your dispute by litigating. But when it comes down to children, litigation doesn't work. You really need to take a look at the global picture, is that these children need to be raised by their parents. When the children have crises, which they will during the course of their lifetime, they need their parents to be there, and they need their parents to be able to talk to each other, communicate with each other. So when parents come in to my courtroom, right now, I'm trying to explain to them that the global picture is your kids need you to be the best that they can be. You need you together to do that. And if we can't send them to mediation or that doesn't work, we also can send them to co-parenting counseling, which is therapy where they sit down with a therapist and talk about how to raise your children together. We also have a program, a parent education program, which the court system has set up, and we can mandate parents to go to that. There's several providers in our area, and it's a wonderful program, shows that the parents the effect of their separation and their fighting over their custody of their children, what effect that has on their children.
Judge, it seems in my own courtroom that in the criminal cases that we manage here in the town of Colonie, that oftentimes addiction is underneath many of the criminal charges that are pending. Do you find that also is occurring in your own family court?
Yes, it's occurring so much so that I've established two drug courts, which are specialty parts in family court. One is for adults who have addictions, substance abuse or alcohol addictions, which impair their ability to properly care for children, and they're charged with neglect. And the children are either removed from their custody or with relatives. And we work on incentives to get them through, to graduate through the program. We've had 70 graduates so far, and over 130 children have been returned to their parents or they've been adopted. Over 100 been returned to parents, and 30 have been adopted. And for the juveniles, the same thing goes. I have a juvenile drug court. The juveniles are on probation. They're in jeopardy of being placed. They're not going to school. They're using drugs. They're, maybe even some criminality involved. We have the same aspect for them, and that is to graduate and either get their GED or get their high school diploma and move on with their lives. So that's been very rewarding too.
Judge, you've told us at the outset that nearly half of your cases may involve some type of custody issue, but you also mentioned too that approximately the balance of the court calendar may include significant matters involving juvenile delinquency and persons in need of supervision, and also neglect and abuse cases as well. Judge, tell me something about the juvenile delinquency and persons in need of supervision. What goes on there?
Well, New York State has a phenomenon because 18 is the age of majority, but under New York State law, New York is in fact only one of two states which treats 16 to 17-year-olds as adults. There is a movement now by the Chief Judge, Judge Littman, and the legislature to study that and maybe move to the model of moving the age of criminality to 18. But right now, if you're under the age of 16, you get charged with a crime, you would come to family court. If we're 16, you would go to an adult court, your court or another justice court. Persons in need of supervision is juveniles who are under the age of 18 that are not going to school, they're ungovernable, they're using substances, illegal substances, and a parent or a school could bring them into the court system. But right now we're working on diverting them away from the court system and be involved in services at the probation level. So we're very successful doing that. And even now, minor juvenile delinquency cases are diverted there also. So basically in family court, we're seeing the most severe cases of PINs and JDs, and under the PINs it would be juveniles with mental health, and JDs would be violent crimes.
Now, Judge, you also have a significant body of caseload dealing with neglect and abuse. What's the typical scenario there, or is there one?
Well, Article 10 of the Family Court Act says if a person is neglecting a child, they could be brought into the family court system to address those issues. And then the severe was an abuse of a child. If somebody, was using excessive corporal punishment on a child and the child was injured, Most of the cases come by our reporting system. We have mandatory reporters such as doctors and nurses, teachers, policemen, school nurses. But also, we have a hotline. Everybody's aware of the neglect hotline, and that there are anonymous phone calls that need to be investigated. In fact, as the supervising judge of the family courts, I'm on call 24 hours a day when court is not in session to provide a basis to allow caseworkers to enter a home, sort of like a warrant to allow them to go into a home. But it's under the Family Court Act. But when the parents come to family court, before they even come to family court, the Department of Children, Youth, and Families of Albany County works with that family to devise what type of services they need to assist them in taking care of their children. And that works many, many times because we have wonderful service providers in our area. But we do see, tremendous cases where children are injured and their people are responsible for them. A lot of it has to do with some of the subjects we talked about before, which is addiction, domestic violence. So we need to address those.
And the domestic violence issue is something that sadly fills a tremendous part of my own caseload here. And it was something I was unfamiliar with as a young boy growing up. It's presented to me daily here in the Colonie Justice Court. And oftentimes I do find that at 3 in the morning, I'm essentially in somebody's living room. Directing traffic on who can go home, who can't go home, and issuing orders of protection, which are, of course, a staple of the family court as well. It's a tool that you have there as well. We both have that power to issue those, and it's a very common exercise now for our local judges to be called out into the living rooms to be able to navigate a situation that's going on there. And oftentimes I'll find out that they also have a petition pending in your own court as well. And I'm being asked to issue an order of protection, but make it subject to an Albany County Family Court order of protection to at least try to facilitate the children's opportunity nonetheless. But the crossover, and I imagine much of it is the emotionally charged environment that the parents have found themselves in.
Well, Peter, the emotionally charged environment is what triggers coming to your court under these incidents and coming to family court. We have to remember is that what we need to be aware of as judges is the fact that domestic violence does affect children, and in fact children can be traumatized by that. So we have to be very aware of that, and when they come to family court and we issue emergency orders of protection, sometimes because of the children are being affected to such a degree, we need to take that domestic violence away. So we'll do stay away orders where parents will have to stay away from the children. We'll send parents to substance abuse treatment. Lots of times there's issues where parents have gone to the Capital District Psychiatric Center. We're aware of that. We issue orders based on that. But truly, in our society, we're much more aware of the effects of domestic violence. And domestic violence could be the yelling and screaming, but it also could be physical assaults, and it could be threatening the lives of somebody. And we have to be very aware of this has a traumatic effect on children. So we do what we can in family court to protect the children, and we issue temporary orders of protection.
Well, Judge, the types of cases that you have are certainly varied and very significant, and I know that the guiding principle is typically what's in the best interest of the child as you move forward in adjudicating your matters. I've seen in the Colonie court over the years actually an increase of defendants that do not have English as their primary language, and that typically what I need to do is to decide whether they can understand what's going on in my courtroom, and if not, I have to engage an interpreter on behalf of the defendant, which only underscores that our community and our greater capital region is probably being continually increased by people coming from other countries and other cultures coming into this area. And do you find that that has an impact on your own caseload?
Yes, unfortunately, the problems of families just don't exist for the families that live in our community that have grown up here. You're absolutely correct. Our proximity to New York City allows a lot of immigrants to come here. The job opportunities are here, particularly now with the high tech and our medical facilities and our universities, which have foreign students who stay here. They bring their cultural differences, and when families have problems, those appear in our court. And yes, we have to utilize interpreters. Obviously, Hispanic interpreters are the predominant ones, but we do have families now coming from India, from Afghanistan. Regularly we have Urdu interpreters coming in.
That's right.
The State Department has relocated many families into our area as political refugees, and they bring in cultural differences. In a lot of the cultures that we're dealing with now, women do not have the same rights as they do in the United States. And a lot of cultures, don't allow women to work. And now that they're here in the United States, they have the ability to go to school. We have even some cultures where females and males can't go to school together. Now they come to the United States, and that's an issue for them. They're restricted if they come from, all over the world. So when they have problems, they come to family court and they present language problems and cultural problems. But we're well aware of that. We have access interpreters, as you said, and we have wonderful service providers in our area who deal with a lot of these families. And we also have a liaison with the State Department for political refugees.
Judge, in addition, I've noticed that the state legislature continues to expand the definition of family. And in my court, for instance, the idea of whether I'm going to use a family order of protection or a non-family order of protection, often a judge has to make a decision of whether the judge believes there's a family here, and so that this family order applies, or a non-family situation. And even in your own court, I would imagine, too, that definition of family and the entitlement that it provides for people to have standing to bring a petition. Have you seen that expand in your own court?
Yes, the family offense provision statute of family court, Article 8, of family offenses has been expanded. It was left to be, between relatives, between blood and marriage. We have children in common, you've been married together, but now it's expanded to intimate partners, which allows for same-sex couples or for boyfriend and girlfriends to come into the court when there's relationship breakups, with the same normal requirements that they have to allege, criminal activity, harassment, assault, just as relatives do. And there's been a proliferation of that, and rightfully so. They should be able to come to a civil court, not necessarily go to a criminal court where the burden of proof is higher, because they're looking for some relief, and they should be able to access the court. So we've seen a rise in those. There's much more awareness within the community, within the police agencies, to direct people to family court. It does put a burden on the family court system because, as you're well aware of, with all the mandates that come from the legislature to the court system, there really is no more assets given to the court. As I mentioned before to you, when I started in 1991 with 8,000 petitions, we had 3 judges. Now we're doing 18,000 petitions. We still have 3 judges.
Right.
So I mean, the legislature has provided some legislation to provide a 4th judge for Albany County, but that legislation has never been passed.
But certainly the caseload supports that position.
Yes, it does.
Yes, it does. And right or wrong, many of the courts, even our own town court in that way, is certainly, the volume has increased, but also the character of the cases and how much more involved they are, and the additional requirements set forth by this court system on what we must do to consider a particular case makes it much more complicated than it was 20 years ago.
Yes, there's much more awareness of mental health, mental health illnesses, domestic violence, and also probably the most significant is drug addiction. You know, from alcohol to more serious drugs. There's a proliferation of addiction and drugs in our community, and these affect families and even parents that have these. So, you know, there's more people aware of this, which means they're now accessing the court system to seek assistance.
Judge, I'll see many types of cases in your court where actually parties were able to gain a divorce in a matrimonial action that was pending in Supreme Court, but then within a period of time, those two parties are back in your court either trying to enforce some type of agreement that they had made as part of the divorce, or to get some more clarification on where they should be, or possibly things have actually changed over time. Do you see that happening a lot in your courthouse?
Yes, Peter. I mean, the last phrase you used, changed over time. I think some people don't realize that once they get divorced, that the documents they put together, their agreement, unless it's very, very flexible, their children are going to grow and different problems are going to come in existence, or people are going to change their jobs.
Right.
And now they have to come into court. When these people come into court that have already been divorced, we're trying to, once again, send them to mediation or co-parenting counseling, because most of the people are working on schedules for children, how they're going to share their children. And obviously, when they can't come to a conclusion because they don't get along, we really can't litigate that. I mean, you really can't litigate. You know, if they're raising their children in separate households, they have joint custody, they really need to go to mediation or co-parenting counseling to do that. So they come to our court because they have nowhere else to go. They can't go back to the Supreme Court and relitigate their divorce because they're already divorced. So we see quite a few people that come along. And eventually, I think they come to look at the global picture, the overall picture, and you know, through mediation, and they can get that done.
Well, Judge, it seems to be a common theme with what you've been telling us today, that actually the community-based services that we enjoy here locally are a great assistance to you and your fellow judges in working through family court issues.
That's true, Peter, and I'm just a little pessimistic here with our budget crisis that we have, that these community-based agencies will lose some of their funding. We've already seen some of that, and they're trying to retool what they do. But these families that we're dealing with and these children we're dealing with need services. They're going to be the future of our community. Right. And if they have untreated mental health or untreated, you know, addiction problems, because we don't have enough programs for them to go to, then as they become adults, they will now enter your court and enter our jail population and now lead into criminality. Right. They won't get their education. So we're really looking at a long-term situation, and if they take the funds away, we can't do that. But we're very blessed by a lot of community agencies dealing with substance abuse. You know, one of my mentors, my high school teachers, Father Peter Young, runs an excellent program. I mean, the bishop was involved in starting Hope House. St. Right. Peter's runs a tremendous. You know, we have a lot of other ones too. I'm going to, you know, miss a few, but. You know, there's also Project Strive, which helps out teenagers afterwards. We have right here in Colonie, we have a wonderful youth program. There's a lot of counseling services. All the schools are much more aware of this. They have excellent guidance counselors and programs. Just recently, the Albany School District, they always had a program in the high school for girls who got pregnant and had children as teenagers. But they never thought about the effects of bringing a child into the world on the fathers. So now they have a program for young fathers, which I think is tremendous. We have after-school programs. We have an evening reporting center where juveniles can be directed by the court system or by probation to go. That's a 3 to 8 program where they get counseling, they get fed. Their parents are involved, they help them with their schools. So we have a lot of different things that we're utilizing now to help out the youth. But if we take away the funding, then I think in the long run our community will feel the effects, and that's not good.
Well, Judge, your commitment to the youth of our area is certainly well demonstrated. I know that you were a founding director of the Police Athletic League here in the city of Albany. And of course, you've had a long time commitment and relationship with our own Town of Colonie Youth Court, which has only been to our advantage. And it only underscores your commitment to the youth of our community, which you and I both recognize is our future.
Well, there's an old saying, Peter, you know, a person's destiny is not a matter of chance, it's a matter of choice. And we have to give our young people, our teenagers, our juveniles, the opportunity to have a chance here so they can make that choice. And if they don't have a chance without these programs, then their choice is inevitable. They will not be productive citizens in the future.
Well, you know, and how children are taken care of even in a divorce as well is always a significant issue. And there are certain types of agreements that are made about the parent's continuing obligation in connection with college expenses. And in some states, maybe the obligation doesn't exist because maybe the obligation to take care of your child ends at 18 in some states, but I believe New York might carry that a little further and extend that to 21 in certain circumstances, and college expenses are a big part of a young person's life.
Right. Well, we mentioned before that I think sometimes when people get divorced and they put together their agreements dealing with custody and dealing with future support of children, they don't realize the fact that New York State does require after 18 a person to be responsible for the support of that child if they're going to college. And we do see quite a bit of litigation on that. These would be people who have considerable amount of money, also people who don't have money but have their children are going to college are looking for support of that child. And it's certainly an area that people should be well aware of. Unfortunately, they're not, because you know nobody's looking that far into the future. But as we all know, if you want your child to go to college, you should start saving early. But
that's right.
But as we both know, but I mean, this is an area of litigation because college is so expensive. And obviously, if a child goes to college, both parents have to submit their financial applications, and that's difficult for people and to do when they were divorced and they didn't plan on this. So it is subject to litigation. But I've seen a lot of people realize that their college is important for their children, that they really have to come together to do something with the money that they have. And a lot of people work on agreements even if they've been in the litigation model in court.
Well, Judge, and I know that from time to time we may make decisions which can be appealed to a different court, and I think that there's a certain a case that you had presided over and rendered a decision about college expenses, which was appealed, and the appellate division affirmed your decision.
That's correct. In that case, the father who got divorced when the child was very young agreed to pay for the child's education, tuition, and books in considering the choice of the college with the mother. Now,
right.
That was the language. I don't know what it meant, but
right.
But his son got accepted into a very prestigious college in Boston, mm-hmm. and his father said, "Well, Mike, I want to consider sending him to a New York State school."
Right.
And we had a debate over that.
Sure.
But basically, he did have the means. He just didn't want to fulfill his obligation. Anyway, the appellate division said that because the child was over the age of 18 and under the age of 21, the father still had the obligation to do that.
Well, Judge, your caseload shall continue. You said something interesting to me before we got going, that divorce often ends in marriage and the resulting issues that go with it. And what did you mean by that, Judge?
Most of the time in our society and our nature, people, men and women, do want to have future companionship, even if this companionship didn't work out. Right. And what happens, that leads to blended families, which can cause some strife between the original mother and fathers here, because now they're working on schedules with, our kids, your kids, their kids,
Right.
and they come into court and they need to put something together that maybe all the kids would be together at one time when you're working on agreements. So it does cause a little bit of a scheduling problem. But once again, these are not litigation. There's nothing in the Family Court Act that says how you do a shared custody arrangement. How do you share your children? So we're, once again, with these blended family situations, we're sending more and more people to mediation.
Well, Judge, you can tell as this this brief period of time has passed that no amount of time could do justice to your professional career and your career as a Albany County Family Court judge. And we're so happy to have you here, a citizen and resident of our town of Colonie, which makes us also very proud. And we continue to look forward to your presence in our Albany County Family Court, Judge. And thank you for taking your time to come here today.
Thank you, Peter. I really enjoyed talking about this. I love being a judge, and I love helping people out. And anytime you want me back here, I'd be glad to come back.
Well, we would always look forward to that, and our best wishes to your family and a daughter in college who's a very special young lady.
Thank you very much.
Well, we're thrilled to have you, Judge, and thank you for coming out. I'm Colonie Town Judge Peter Crummey, and thank you for joining me on Benchmark.